Okay, so it looks like most people have joined now. Welcome everyone to the latest SCCJR Justice Futures seminar. My name's Oona Brooks-Hay. I'm the Director of the Scottish Centre for Crime and Justice Research. As most of you I think might know by now, the Justice Futures seminar series critically explores social harms and institutional responses to those harms with a view to thinking through what justice can and should look like. Today, we're focusing on violence against women and girls, which is an area where debates around justice are particularly acute and particularly challenging. So, I'm really delighted that we're joined today by Professor Clare McGlynn, Professor of Law at the University of Durham. Clare's work has made a huge contribution to understanding and informing responses to many different forms of violence against women and girls, and that includes tech facilitated violence. So, our presentation today is going to focus on some of the quite challenging debates around anti carceral feminism, drawn upon the perspectives of survivors of tech facilitated violence against women. Clare will speak for, I think, around 30 minutes, so there'll be plenty of time afterwards for questions, which you can either pop in the chat or you can pop your hand up at the end of the discussion. So without much further ado, I shall hand over to Clare.
Okay, thank you. Thank you very much. Thank you very much, everyone, to spending your time with us today, particularly on, what is, I hope for most people, a lovely sunny day. So I very much appreciate that. Oh, wait a sec. Sorry. Need to, where are we? Try and share my screen. Right. So is everyone seeing that screen okay? Yeah? Does that all look okay? Okay, thank you very much there. So yeah, what I'd like to do today is to talk about some of these debates around carceral and anti-carceral feminism, and particularly bringing to the fore some of my work around tech-facilitated violence against women and girls. So some of you, will be familiar with some of the work I've done in this area, but I want to try and set that out to try and set the overall context for my arguments, really. And a lot of this work around justice perspectives stems from this work I did with my colleague Nicole Westmoreland a number of years ago when we were speaking to victims, survivors of many different forms of sexual violence about what their understandings of justice were. And from those discussions, we came up with this concept of kaleidoscopic justice to try and explain the kind of the wide variety, in summary, of ways in which women and girls understand justice, and justice as constantly shifting, ever changing, different for each survivor. And crucially, that justice is more than a conviction in the conventional justice system. Now, that work also then led to other similar work in the same field, developing some of these ideas of justice, and particularly around restorative justice. And I know many of you here as well are experts in that field. And what I've looked at, again, with colleagues, Nicole Westmoreland, Nikki Godden and others, is the fact that some survivors do wish to pursue forms of restorative justice in relation to sexual violence, and including some of my work there with your very own Kelly Johnson, again, where we looked at the police using some of those forms of restorative justice, although in that context, it was with a lot of concerns. So a lot of my work has been about trying to expand our ideas of what is justice and to look beyond the conventional criminal justice system, listening to the voices of survivors telling us that for them, for some of them, restorative justice and other forms of justice is what they're seeking. And so these are just some examples of the voices of victims. So one, Lucy, who talked about restorative justice because she said, I just wanted him to hear me. That was what was more important for her than to have him go to prison. That was Lucy's perspective. And then there's other comments there from other women who again talked about the admission of guilt, it being critical, the recognition, and then also that actually prevention was the form of justice. So rather than a conviction in their case, if they could prevent it for others, that would constitute justice. But at the same time, in this work, and this is what I then returned to in the last couple of years, women and survivors are also saying that for some, criminal justice is meaningful for them. So justice for them is a guilty conviction. Another woman in the same study talked about the only kind of justice is prison. I would have liked him to be exposed for what he was. And this is echoed in the work of some other organisations. So, for example, the organisation IMCAN, who works with Black and minoritized women, one of their reports a few years ago talked about how criminal justice was an important objective for many survivors, motivated out of a need for justice and protecting other women. So some of my work in many ways went on a kind of arc from looking at the criminal justice system to looking at other forms of justice like restorative justice, but then returning back to criminal justice and thinking about the voices of survivors in that context. And that was also particularly because much of my work over recent years has been around technology abuse and basically identifying the kind of gaps in the criminal law in relation to forms of image-based abuse and other forms of technology-facilitated abuse. Basically because, the experiences of women and girls in this field falls between the gaps in the criminal law, because the criminal law was designed with forms of tech-facilitated abuse, and particularly those experienced by women. So this includes my work on cyberflashing, my book there, which I did with Kelly Johnson, and other work around image-based sexual abuse, and most recently, changes to the law around deepfakes. And so that was I have been, using and arguing for a criminal law foundation to our response to these forms of abuse. But that's not just in the UK in the sense, I mean, I know that many of you will know this, but just to underline this point, across the European Union, there have been changes to the criminal law as well in this field. And I highlight here, again, it's been survivor-led organisations. So Stop Fisher is an organisation set up by survivors in France. Now Partillas in Portugal, again, a woman who experienced image-based abuse and set up an organisation that campaigned for change in the law, as did Silvia Somenzin in Italy. So these are, survivor-led experiences, campaigns, they were wanting a criminal law response to their experiences. And why the criminal law? And again, many of you have done, the depth of research and conceptual research in this field, looking at reasons for criminalization. But just to summarize some of that here. And again, for me, it's about how some victims seek criminal justice, because that recognizes and validates some victims' experiences. That's what they essentially understand then when their experiences are recognized. It may provide a sense of justice and redress for some. It can be a powerful, expressive, communicative role for the criminal law. There is indeed a problem with over-criminalisation, but often there's an under-criminalisation, as what Mary Anne Franks has, a number of times said, about the harms experienced predominantly by women. And it does provide a foundation, I think, for educative and preventative action. And we can come back to this. One of the things that's about the interrelationship with the Online Safety Act. The Online Safety Act basically gives higher responsibilities and obligations on platforms in relation to illegal content. So it then becomes more important to have criminal law foundation if we're going to then see some of those harms reduced by platforms. I mean, you might say that that's regrettable, and there are some challenges with that, but that is the approach in the Online Safety Act that we have at the moment. So let me then turn to what are some of the critiques of this kind of criminal law response. And anti-carceral feminism, and abolition feminism kind of interrelate, have a lot of, exceptional points with which I fundamentally agree, in the sense that there's a very justified concern with the over-criminalization, particularly of Black and minoritized men, and the systematic injustices facing Black and minoritized women in many countries, including the UK as well as the US. It's also part of a very justified critique that there's too great a focus on individuals when you're talking about a criminal justice system, rather than the systemic and structural reasons for crime, abuse, and harm. And often, the critiques that there's a lack of focus, often, including in this country, on alternative and innovative justice mechanisms. There's often not the space, particularly in public debate, to talk about these alternatives. Although in Scotland, you've managed to introduce a few more of these sorts of processes than certainly in England and Wales, and Northern Ireland has done as well. And many of these critiques, I do identify the clear risk of feminist co-option by the kind of neoliberal and conservative forces. And of course, we see this without a doubt in politics at the moment in the UK, and populism across Europe. It's very clearly the kind of a feminist anti-violence message gets co-opted by the far right. And for me, abolition feminism, I think, is inspirational. It is, it's an end point, envisioning a future where oppressions based on race, class, ethnicity, and marginalization no longer exist. And that is indeed a world worth striving for. In some of this, in some of this work, there has been a turn to look at the tech-facilitated aspect of violence against women and girls. And this is where I think I have many concerns, sometimes about the minimization of this form of abuse and certain caricatures. So Aya Gruber talks about how feminists should not propose new substantive offences or higher sentences for existing gender crimes. But she also objects to new laws criminalising non-consensual distribution of intimate images, for example. And she refers to some of these forms of abuses as, quotes, the ways people mistreat their exes. She refers to it as bad internet behaviour. And she talks about a problem of criminalising what she says is minor offences like over-the-clothes sexual contact. And I think those ways of describing harms that are devastating, life-shattering, and for some people they're life-ending, is, minimises the nature of those harms. It's not bad internet behaviour when it's constant online abuse that can lead someone to having suicidal thoughts and sometimes people ending their lives. And that's at one end of the extreme, and many thousands and millions in between having their lives devastated and their professional chances often curtailed. She says, instead of narrowly focusing on a few image distributors, advocates should seek to change social, familiar, and employment practices, which is absolutely true. It's absolutely true, but for me, that doesn't come at the expense of actually also focusing on perhaps some of the image distributors. Philosopher Amia Srinivasan talks about a feminist politics which sees the punishment of bad men as its primary purpose will never be a feminism that liberates all women, for it obscures what makes most women unfree. And I suppose what I find difficult about this is that I think very few, I'm not sure I know any, who are advocating in this space say that all we need is the punishment of a few bad men, as if that is the solution. Most of us do not think that that is the solution, and a multifaceted, holistic approach is absolutely essential. So in response to many of these debates, as many of you will know, there's been a growing critique And these are just some examples of other feminists who've been developing some of the ideas challenging this. So Anna Terwell talks about the critiques, the binary choices that were basically being put in boxes. And she talks about the need for a spectrum of decarceration. Lise Gottel talks about needing to see the breadth of feminist goals, and Masson talks about the erasure of nuance. And so this brought me to some of the work I did a couple of years ago when I've suggested that we should think more about the kind of continuum thinking from Liz Kelly and Karen Boyle to challenge these binaries, the boxes being put into were either anti or supposedly pro-carceral, and understand ambivalence. And in that work, I also drew on Oona's work around how some of the survivors she spoke to as well sought a criminal justice approach. Not all, but some do. And I'm particularly concerned about why is it that the survivors of these so-called new forms of sexual violence, like tech-facilitated violence, are being denied the opportunity to seek justice on their terms. So we're told that we must not advocate for any, quote, new criminal offences. Why? Why is it that those victims, the thousands of women experiencing these kind of devastating harms from online abuses, aren't entitled, if you like, to the same sort of criminal justice redress that, say, a physical assault you can under existing law? Because many of those arguing for anti-carceral critiques aren't talking about a reform, abolishing the law of rape, but you're keeping in place some of those existing structures. We're just not supposed to have any new ones. And so I want to give a couple of examples really of I suppose in more detail, the work that I've done with some survivors, and to try and critique this position. And very briefly, this is Sally Rees, who is a teacher from Northern Ireland, who one of her pupils took videos of her and another teacher up their skirts. And the school refused to do anything. The police at first refused to do anything. She had to take a judicial review to challenge the police's inaction. And she then campaigned for a law on upskirting in Northern Ireland. And you can see, from some of these headlines, she was successful. And I worked with her over many years about this. And she certainly has talked there, one of her quotes, the trauma being compounded by having to fight for what she said was justice and recognition. So for her, this absolutely was about justice through recognition by the criminal justice system that what had happened to her was wrong. And that was very much her view, supported by many others, and the laws changed. But to caricature her as only pursuing criminal justice would be deeply unfair, because, for example, amongst her other work that she has done since then, including through the Teachers Union, the NES-UWT, has been to campaign for better sex education in schools, better protections for female teachers, and basically a far more holistic response to sexual violence, but including tech-facilitated sexual violence. So it's a holistic position. It's not about saying there is just one criminal conviction will solve this problem. And then another example I wanted to talk about is a survivor of deepfake sexual abuse, Jodie, another survivor I've worked with for many years, who had sexually explicit deepfakes made of her without her consent shared online, including images of her being raped by a teacher and what have you, and the abuse that she experienced. And working with her, she's one of the advocates for changing the law around the criminalisation of creating sexually explicit deepfakes. So there is now in England and Wales and Scotland are consulting on it, a law around a criminal offence to create or ask someone else to create sexually explicit deepfakes for you. And she, with many others, End Violence Against Women and Girls, Not Your Porn, and Baroness Owen and others, campaigned for that change in the law. But again, that was not that was one part of a broad campaign, and this is just these are just some of the other aspects of that campaign she and myself have been involved with about stop image-based abuse, which has also been about changing the regulatory structure. It's been about relationships education in school. It's about expanding the civil law response to these forms of abuse. So the criminal law has only ever been one part of that broader project, but it is a part of it, but it's part of a broader project, and it's certainly not about saying the criminal justice system is the only answer, or indeed that it's the perfect answer. So I want to then just close by thinking about some of these imaginative approaches to the criminal law and criminal justice system. And then one of the more recent, just before I get to that, sorry, one of the more recent critiques around of the anti-carceral critique from Molly Ackhurst, who has talked about, has critiqued, including my own work, for being survivor-led approaches that she says refrain from asking why the survivors said they wanted to involve the criminal legal system. And she talks about how some of these survivor-led, like mine, approaches has fantasies about justice that might not be realistic. And what we should actually be doing as academics is encouraging a reframing of those fantasies around safety, closure, and protection. So it's my response to some of this is actually that I've no problem with being characterized as survivor-led. I do think I need to listen to and be led by the voices of survivors who have experienced these forms of abuse, because certainly in my experience, the women I'm working with know absolutely all about the challenges, about the broader picture, but they also know very clearly and understand very clearly what justice means for them. So I don't find that trying to suggest that I should reframe their voices as an approach that I particularly want to take, nor in fact that I think others should take. I think we should be listening to the voices of all survivors of sexual violence, even when we disagree with them. I don't agree with every approach of every survivor, but I don't think I should reframe them because I don't think I should be reframing them. I should be listening to all of those voices. But also part of my work, and then this is where it can become challenging, isn't it? It'll be interesting to see, is about emphasizing justice here and now for survivors. And I guess that's what a lot of my work has been about. Women who right now are experiencing forms of harm and abuse, and who right now are seeking criminal justice responses for them. And that's what they're seeking and what they want. And that's where it also comes to working with the police as well. Because criminal law reform, I think, can provide a form of hermeneutical justice, recognizing and reframing women's experiences. And that's why I think reforming criminal justice systems supports those choosing to report to the police right now. So, of course, in Glasgow and in your centre, many of you have been working on Project Bluestone Soteria, which is the project in England and Wales seeking to transform and improve rape investigations. And it's not perfect, but it is making significant changes to how women are being treated in the criminal justice system right now. And that is certainly work that I've been privileged to be involved with as well. But it's work that is challenged from some anti-carceral feminists, because we should not be supporting the police in their endeavours. But I guess what I'm saying is my approach is to support women in the here and now who are seeking that form of justice. And then one of the more kind of foundational concerns really is that I think some of the anti-carceral feminist approaches basically risk reifying existing stereotypes, assumptions, and hierarchies of harm. And what I mean by that is that it seems to privilege the kind of physical, offline forms of sexual offences, because there's no proposal to decriminalise them. But there is proposals not to criminalise the forms of online abuse. And I think that does just, it plays into the debates. Those of us who are involved in fighting online abuse all the time, having to fight this idea that it's not as serious and it's not as harmful and it's not as significant as physical offline abuses. And that's just not how many women, well, the women I speak to, experience it. And I think some of the carceral, anti-carceral perspectives, so of course people take lots of different approaches, does appear to reject or undermine some of the ideas of the continuum of sexual violence, which Liz Kelly's work, which challenges a hierarchy of sexual harms and experiences, and also tries to understand them as interconnected, which I think, you know, one needs to do in terms of understanding better the online and offline experiences of women and girls. So just to try and draw things to a close. So Aya Gruber does talk about the use of the criminal law as a product of the failure of imagination. And at one level, that is true. In many criminal justice systems, we do appear to keep repeating the same sorts of problems and failures. But stepping back, so much of my work is pragmatic, but if I'm to step back as well a little bit, I think what I also see, though, is the failure to imagine a different criminal justice system. The current criminal justice system does not have to be that way. It doesn't have to be as it is. It doesn't have to be so punitive and so focused on incarceration, for example, as the be-all and the end-all. You know, accountability for crime, as I say here, is not necessarily automatically about punitiveness and punishment, but could be about recognition, prevention, consequences, forgiveness. Do I know exactly what that criminal justice system looks like? No, I don't. But then that should not stop us, I don't think, trying to find or search for or try and imagine that type of criminal justice system, as well as trying to imagine these other ways of being, which are being promoted in other forms of transitional or transformative justice. So I guess I'm saying I'd like us to try and think of and adopt similar energy and strategy to reimagining that criminal justice system, which is what some survivors are seeking, as well as trying to imagine at the same time the alternatives. Because from my perspective, it would be putting the two together and giving a full range of choices and options for redress that survivors are asking for, you know, that full kind of kaleidoscopic approach to justice that I think survivors are asking for and deserve. So Carol Smart talks about, as we all know, decentering the law, but she does also talk about that does not mean abandoning it as a site of struggle. And for me, the law and criminal law does shape and dominate our lives, which is why I want to engage with it really and try and make it as work best for survivors as is possible. Of course, it's a challenging, complex process. We have to harness the transformative power of law, as well as recognizing its capacity to reinforce disadvantage. But I don't think that means we should stop trying to engage with it and challenge some of the oppressions. So, as I say, my call is to imagine that future where a transformed criminal justice system is one part of a holistic and comprehensive approach to ending violence against women and girls. So, thank you very much, everyone.